Good afternoon and welcome to Queer Town Hall. Today we will be talking about the Supreme Court and what the current makeup of the court could mean for LGBTQ equality. Many of us watched the partisan fights around the opposition of the appointment of Merrick Garland and then the fraught appointments of Neil Gorsuch, Brett Kavanaugh, and most recently Amy Coney Barrett to the court, following the death of Justice Ruth Bader Ginsburg. When we thought of this show, it was before the election when we were in a place of high anxiety about our rights. I think we all breathed a sigh of relief after Trump lost the election, but I know for a lot of people, there's still some lingering fears about the courts. And we're hoping to have a really lively conversation today and also answer any questions you have about how to protect your relationships and your family, or testing out whatever doomsday scenario keeps you up at night. So as always, you can ask questions via the YouTube chat, and people who comment or post questions or donate to help cover the cost of our live captioning will be entered to win a Protect Trans Kids tote bag, which looks like this. So let's start with introductions, and I'm going to ask you your name, your pronoun, the work you do in the world, and what book, movie, or show have you most enjoyed during the pandemic? And I always go in alphabetical order, so let's start with you, Beth.
Hi everyone, my name's Beth Wolfsong. I use pronouns she, her, and hers. I'm an attorney here in Portland, and we practice, my wife Jen and I practice in the areas of estate planning and family formation law, meaning adoptions, donor and surrogacy contracts, etc. During the pandemic, I just read a book called Code Girls that was about the impact of women code breakers during World War II. That was pretty fascinating.
Wow, that sounds super interesting. Code breakers, put it on my list. Yep. And what about you, Jen?
As far as books, I read Rage by Bob.
Sounds like we're having the same audio problem and that you are can't hear you at the moment. So I'm going to actually ask Lorena if you want to introduce yourself while we figure out the audio for Jen.
Sure, I can do that. I'm Lorena Reynolds, she, her, and I am an attorney in Corvallis. I manage the Reynolds Law Firm. And I was thinking about the books that I was reading. I kept thinking, am I going to admit that really what I've been doing is watching TikTok? But I have been doing some actual reading. And I think my favorite read since pandemic was Being Human, Heumann by Judith Heumann, disability rights activist. It's sort of a memoir you don't hear the name a lot, but it was really powerful read.
Wow, that sounds great. Matt, would you like to introduce yourself?
Sure. Hi, Nancy, and hi, everybody who's watching. My name is Matt Dos Santos. I use they, them pronouns, and I'm the managing attorney at an organization called Our Children's Trust, which brings constitutional and human rights climate cases on behalf of youth around the world. I'm also on the board of directors for the Transgender Law Center, which is who I'm sort of speaking on behalf of today as we dive into some of these issues. The book that I've really enjoyed reading recently is called Devils in the Grove, and it's a book about Thurgood Marshall's time as the director of the Legal Defense Fund at the NAACP and some important cases that he litigated relating to the conviction of innocent Black men in the South. And it's a really beautifully written book. It won the Pulitzer Prize and is it's an incredible piece of work about our legal history and around civil rights.
Wow, that sounds super fascinating. And then I will go to Nora, and then I'll jump back to Jen. So Nora, would you like to introduce yourself?
Yeah, I'm Nora Broker. I am an attorney in Portland. Until recently, I was a associate at Bennett Hartman law firm for the last few years, where we practiced labor and employment law, representing workers and unions in labor, employment, and also civil rights litigation matters. Recently stepped away indefinitely for our family childcare needs due to pandemic. We have a 1-year-old, and so that is my occupation. I'm also on the board of OGALA, the LGBT Bar Association of Oregon. I'm judiciary chair and our legislative chair. I realized I've done more reading than I thought this pandemic. A couple standouts: the poetry collection I love. Oliver Bay's Bendorf, Advantages of Being Evergreen is great. Later by Paul Lisicki, a memoir about Provincetown. And I finally read Stone Butch Blues. Like, I should have done that years ago, but I'm better late than never. So, also pronouns she and they.
Great, thank you. So let's go back to Jen. Yeah.
Thank you. So my pronoun is she. My books that I have read during the pandemic that I really like, I did read Rage by Bob Woodward. For fun, I'm reading this series, The Best Ladies Detective Agency, and it's about a lady detective in Botswana, and it's a whole series of books, and they're really fun.
That's great. And yeah, I have not asked this question to any panel before where everyone has read books. So congratulations. And yeah, that's great. So thank you everybody for being here. And I'm gonna go ahead and sort of start with, I think, the question that's been on a lot of people's minds since I know I kind of freaked out a little bit. I think it was about 2 weeks after the passing of Justice Ginsburg when Samuel Alito, just made some pretty bold statements around marriage equality and thinking that it really endangers religious freedom and the religious freedom of Kim Davis to discriminate. And so why don't we just start there and really start talking about, like, is there, like, for folks who are watching at the Supreme Court level, like, do people have fears that Obergefell could be overturned or changed in some way? So I'm going to start with our sort of SCOTUS watchers, Matt and Nora, and then maybe then shift into how you can protect your relationships if you're feeling worried.
Nora, do you want me to start or? Okay. So thanks, Nancy, for that question. It's definitely a fear that I think is on a lot of people's minds. And, it's not entirely unreasonable to be afraid of what this potential new composition of the Supreme Court will do. As folks likely already know, the appointment of Amy Coney Barrett now makes what we consider the conservative majority of the court 6-3. And so we're looking at the most conservative Supreme Court that we've seen in a very, very long time. So the thing that I will say is that I think it is unlikely for the court to outright reverse Obergefell. And I think that for a few reasons. The first is that this hard-fought victory, which came after really decades of trying to win the right to marriage for same-sex couples, has now been in place for the better part of 6 years. And so that and as I've sort of talked about it in other settings, there is the operation of the administrative state. So all of the agencies at the federal level, and then even at in Oregon, all responded to that court ruling by revising rules and by and promulgating new rules about how the various agencies, executive agencies across the United States could treat same-sex couples. So that's everything from how we file our taxes to whether we can get a marriage license. And to undo that, right, and to just sort of like undo that with a Supreme Court case, I think would be really challenging because it could potentially raise other issues about the constitutional rights of folks who have been granted those rights. So I think that if we were doing a little bit of, doomsday planning, I think the most likely worst case scenario, and other folks feel free to disagree with me. I know that there are contrasting opinions on this, is that the reversal of Obergefell would be limited to actions going forward, because the courts really hate to undo things that have happened in the past. And so it could potentially prevent couples who haven't been married yet from getting married. But I think it is unlikely that it would, sort of magically by court action unwind all of the existing marriage license out there. And so that's a problem, right? Because if you have these two different classes of same-sex couples, right, the ones who can't get married and the ones who can, then agencies across the nation have to figure out how to deal with those two different classes, including would the IRS now reject joint filings made on behalf of married couples just because Obergefell was reversed? And so even though that's not in some ways the most hopeful answer, I think the network of laws and regulations that are now in place post Obergefell makes it very, very unlikely for the Supreme Court to take that kind of action because of the complications that it creates. Now, I think there are other potential problems around how we see rights rolled back, or as you alluded to, Nancy, sort of the emergence of this like religious freedom argument being entertained more broadly by the new Supreme Court. Though I will say that, even the recent case against Kim Davis really went nowhere, and the Supreme Court did reject that case, even with what was, it wasn't a 6-3 majority, but it was essentially a 5-4 majority at the time.
Thanks for that. Does anyone have a differing opinion you want to share or add to what Matt shared?
I would just say, kind of looking atmospherically, I think it's great. It's good to appreciate kind of how far we have come, how quickly. Like, I think back to, so the first election I ever participated in was 2004, and that happened to be the year that Oregon passed Measure 36, the constitutional amendment banning same-sex marriage. And on our prep call, I looked it up again to confirm in Wikipedia. Only 2 counties in Oregon voted against that measure, Multnomah County and Benton County, including Lane County, where I was living at U of L. And so we were litigating that up to 2012. Today, I think just the public support and the familiarity and the reliance is just gone so far forward. It has gone from in just the last 10 years, a suggestion of same-sex marriage being a radical proposition to it becoming a radical proposition to try to claw back these rights that we are now so familiar with and so many people have relied upon. And you look at the polling data, on a bipartisan basis, people are coming to accept that this is where we are, this is valuable, it hurts people to take it away. It's just not, it's become a fringe priority. And so I think the lift to get there is going to be stark. And you're talking about Alito, and my advice for people would be to not pay too much attention when Alito starts going off. I mean, so if you want to watch some like Alito horror stuff, last week he went before the Heritage Foundation and went on this just incredibly inappropriate stem winder about all of his political beliefs and how everything that is liberal is bad and just completely inappropriate for a judge. But he is out on a limb by himself with that. I think he's consistently becoming the firebrand in a lot of these cases. But you look at the other conservatives on the bench, they are more circumspect. They're looking to actually find, colorable legal arguments, and then sometimes they're looking at the law and saying, well, maybe this isn't our policy preference, but this is where the law is leading us in, above all in Bostock versus Clayton, the consolidated cases this year where we got a 6-3 majority. 5 of those votes are still on the court. And so, I think as not fun as it is to hear Alito, he's absolutely not the center of the court right now. Which isn't to say there isn't reason for concern, but I think that's kind of important to keep in mind.
Thank you for that. And so, for our sort of family law folks, so on Sunday, for instance, in Portland, there was a wedding-a-thon for LGBTQ couples. Do you think that, as lawyers, are you encouraging people to maybe get married sooner rather than later if they're worried about what's happening at the Supreme Court level? I'll ask Jen and Beth that question.
Well, I always have kind of 2 voices going at the same time when people ask me that question, and kind of the romantic in me is like, yes, get married, go do it, because we can now. But the kind of practical legal advisor in me knows that that's a really individual decision for every couple. And, so I kind of end up somewhere in the middle, which is if you are considering getting married, you want to get married, go do it. Now's the time. But if you aren't quite there yet, then don't go get married just because you can right now. So it's a very individualized decision that should be made per couple based on what is the right decision for you right now. And as hard as it is to say, that's separate from the legal issue of can we or can't we legally.
Mm-hmm. Yeah, that's helpful.
One of the things I usually add too is, because I do the adoptions at the firm, is if a couple knows that they're going to get married and they're planning to have a child, then they may want to get married prior to, because then that establishes the non-birth parent as the legal parent in Oregon immediately.
Yeah. And so, speaking of Oregon, it feels like because same-sex marriage was banned in the Oregon Constitution via Measure 36 in 2004, some folks have expressed concerns that a Supreme Court ruling could somehow reactivate that ban and nullify marriage that way. Folks have, Nora, it sounds like you looked at it recently, or Lorena, if you want to poke at that Measure 36.
Liz, we had a lively debate on this the other day. Who feels brave enough to venture an opinion? I think we weren't super clear, even among us, whether this would be the case. It wouldn't necessarily be usual, but I think especially with the, if someone else wants to venture a more authoritative opinion here.
I'm not sure I want to jump in with a more authoritative opinion here, but in terms of sort of practical on the ground, I mean, there's sort of this great intellectual conversation that we all can have a lot of fun doing, but in terms of on the ground sort of practicality, I'm with Matt that I just think it's going to be, even if we saw the Supreme Court start chipping away at rights or start trying to overturn things, you got to remember there's a lot of layers here. This didn't all happen just in one case. I mean, there was a series of cases building up to this. And so they're going to have to peel those away. And I guess I don't think that there certainly isn't anything in the pike right now where they're going to undo everything all at once. We're going to see it coming. So I think if you're thinking about should we run out and get married, I think you really want to think about why? Why are we getting married? What are the specific rights that we're thinking about wanting to protect? Mm-hmm. And is that something that's at risk right now, if that's the only reason you're getting married is to protect those rights? So I think it's more of I don't think it's the doom and gloom. I think there's definitely this lingering what could this look like? And I think particularly on some of the other issues that we're going to talk about in a few minutes. But I think in terms of marriage and in terms of family rights here in Oregon, I think we're in pretty good position for at least quite a while, and we're going to see it coming for a long time before it comes. And that doesn't mean I'm saying, like we were talking, Jen and I were talking about this in terms of like, you still want your step parent adoption. There's still reasons to take these legal steps, especially if you are somebody that travels across state lines or moves across state lines. But I think here in Oregon, we're in pretty good position, and we are still going to want to be thinking about, for me in particular, why am I getting married?
Mm-hmm.
And so, and one of the to kind of, I'm thinking on the question, and kind of the worst case scenario being that we have a Supreme Court case that does go up, overturn Obergefell, and we have this question. Even if there was a good argument for retroactivity, we are, once again, the litigation calendar is long. It would take years in advance. And even if the law from 2004 was reactivated, that doesn't mean that Oregon is thrown back to 2004. If this is looking like, if we are angling in that direction, like I was talking about, the public sentiment has shifted so radically. Even if worst case scenario it was revived, I would only expect that to be on the books until we could get it in front of the public to repeal it, and we would then be returning to the status quo we have now, which is, I think, just even in the worst case, that will likely be the way that this will move forward, and we will return to having access to these rights in Oregon.
I absolutely agree with that. The political landscape is like that. I think the rights that are most at risk are those federal ones. Social Security benefits and federal taxation. I think those are the first two. That's sort of going to be the bellwether, right? That's going to be where we see a first attack, because it's the most vulnerable, easiest to pick away. But again, I don't think there's, and Matt would know better than I don't think there's anything in the pipeline that's dealing with that yet.
And there are two different questions, because if we recall, we had Obergefell, which overrode state bans on same-sex marriage. Before that, we had Windsor, which was whether the federal government is able to not recognize marriages that were entered into lawfully under state law. And so that is a whole different question, to be going and overturning that recognition as well, in terms of what the federal government is obligated to do.
Yeah, thank you for that. And I just wanted, while we're talking about partnerships and families, I do feel like second parent adoption has come up a few times. And so unless you've been through it, you might not know a lot about it, or unless you're like me and wrote a paper about it in grad school. Why don't we talk just a little bit about what it is and why people should do it, for sure, 100%, no matter whether you're married or not. Jen and Beth, do you want to take that one?
Sure. So second parent adoption is when a couple gets pregnant through the use of assisted reproduction, and then the non-birth parent adopts the child as the second legal parent after the birth. This can happen in a couple ways. If the couple is already married, then they're both already the legal parents in Oregon, because we have a statute that says when a woman gets pregnant through the use of assisted reproduction and she's married, her spouse is the presumed other legal parent of that child. And then the second is, if they're not married, then the non-birth parent is not the legal parent until they do a second parent adoption. And the reason why we do a second parent adoption for the married couple is because not all states have to recognize Oregon law, but they do have to abide by the Constitution's full faith and credit clause that says when a judgment from a court of competent jurisdiction is issued, then that judgment has to be honored everywhere. So that judgment gives them the legal recognition in all 50 states.
That's great. Thank you for that. And then in the case of, say, a gay male couple where a child is born through surrogacy and one parent would be listed maybe as the father, how does that same thing work that way?
Oh, go ahead.
So actually, it's a little bit of a different ballpark. And this is actually, there's a really detailed answer for this. So I'm going to try and keep it simple, but I want everyone to please remember that this is very nuanced. But typically what it comes down to is whether this was what we call a traditional surrogacy or a gestational surrogacy. So if the two dads are having a kid via gestational surrogacy, then typically we don't do adoption at all. We do something called a declaratory judgment of parentage. So we use Oregon's declaratory judgment statute as a way to have the court affirm the parentage of both dads, regardless of whether one of them is the genetic father of the child. And again, we end up with a judgment that is entitled to full faith and credit throughout the United States. Again, there's kind of there's a lot of ins and outs to that. So what I just said doesn't necessarily apply to everybody, but that's kind of the general, most common way that we do that.
And then in a traditional surrogacy, if the surrogate is actually genetically related, it's her egg to the child, then and one of the dads is genetically related, then we have them sign a voluntary acknowledgement of paternity at the hospital. And so then the surrogate, and
if the surrogate's not married,
and the dad, right, is the legal parents, and then we do a second parent adoption for the non-birth dad.
Great. That clarifying that issue. I know we get a lot of questions, and we're always like, get a second parent adoption, you know.
Yeah, it's really important, no matter. And this is one of the ways that I try to frame it for people, because of course a lot of people are frustrated that we have marriage equality right now, and yet we still have to take these extra steps to protect our legal parent-child relationship. And what I try and do sometimes is I try and reframe it as, in a lot of ways, this isn't about marriage and marriage equality. It's about the use of assisted reproduction, which is also a very new area of law, right? The law has not kept up with the science and the medicine of how we're creating our families now. And it varies state to state, right? So before we had marriage equality and we were doing this, well, I've got a civil union in this state and I'm married over here, but it doesn't matter either way if I'm in this third state over here. It's kind of the same boat that we're in with assisted reproduction right now. And so rather than kind of be vulnerable and have that, well, I am a parent under Oregon law because Oregon has a statute that says it's no matter how you're creating your child, whether it's surrogacy or whether it's the wife's egg was fertilized in the lab with donor sperm and then the other wife carried and gave birth to the child. It's no matter how we're creating our kids, if we're using assisted reproduction, we want to avail ourselves of the protection of the court so that we have the benefit of the full faith and credit clause throughout the country. And we're not doing the same thing we did with marriage several years ago, which is wondering, is this state going to recognize my parent-child relationship, or is that state going to recognize it?
Great. Thank you for that. And we've actually gotten our first question from the audience, which is, and hi, Michaela, amazing bro volunteer. Are there any active cases at the district court level that are currently attacking marriage equality or abortion rights, or other notable cases to pay attention to? I will let anyone speak up on that, but I know Matt and Nora, you might be watching some of these district level cases.
Yeah, as far as I know, and of course this can change literally every minute of every day that a court is open, there are no cases in federal district courts that are, aimed at unwinding Obergefell or attacking marriage in that sort of head-on way. There are, it seems like, I think we could do an entirely different panel about abortion rights. There are any number of district courts And as you all probably are well aware, courts of appeal considering various challenges to state restrictions on abortions. None in Oregon, but there are definitely in those states in sort of like the Sun Belt, right, where there are state legislatures that are very conservative and who are like regularly trying to put restrictions on abortion. That I think there are a few cases there. I wouldn't say any are as notable as the ones that were, just emerged from Louisiana and some of the in Texas most recently. But I think that that's something that we are all keeping a close eye on, because I think that that's constantly changing.
Great, thank you for that.
It's almost like a sports season. You can rely on it, coming around every year. That a lot of these red states are, especially since the inauguration of Donald Trump, we're passing every session clearly unconstitutional bans on, and other restrictions on abortion rights. And those have been uniformly, especially the ones that are just categorical bans well before what is constitutionally permitted. Currently, those have been knocked down, but they clearly hope that the more conservative the court gets, that one of these eventually will go through. I would flag that obviously those rights are directly applicable to so many LGBT people. It is also, as that case law develops, is going to be highly relevant to another, the new favorite sport of many red legislatures, which is to ban transition care, especially for trans youth. That's, I think, Chase Strangio at ACLU has been documenting a lot, following all the cases, and a lot of legislatures are now filing, there's a lot of proposed legislation for this upcoming session that will address that. And those rights are very highly related and to the development of, to what's happening with the law around reproductive rights generally.
Great, thank you for that, Nora. So we actually just got another question from the audience, and maybe I'll let Lorena take this one. Wondering what legal protections, if any, are available to partnerships that extend beyond two partners, specifically in triads.
Yeah, that is a big open question in Oregon. That is, there's much more sort of developed law coming out of California, and there's a couple of interesting cases coming out there. But I'm not going to speculate on where that's going to go at this point. I think that is a very, it's a cutting edge, interesting issue. I think a lot of that's going to be judge dependent by county and by judge within county. And yeah, great question. There is no answer. I got nothing. I think the Supreme Court, I think we're pretty clear where the Supreme Court's going to come down on that. I don't think we're going to see the kind of rights that we've seen in terms of federal benefits. I don't think we're going to see those coming down. I don't know, maybe Nora has an opinion about how many years this court is going to be impacted, maybe 30, before we see any move towards the left on that issue. But locally, I don't know. Good question.
Could I jump in with a follow-up answer to that too, Nancy, which is...
Sure, go ahead, Matt.
Okay, which is just that there have been some ordinances, the most recent one that I know of in Massachusetts. It's a city ordinance allowing for sort of like multi-partner relationships. I'm totally blanking on the name of the city in Massachusetts which did that, but I suspect that we'll see litigation coming out of that, those sort of more progressive municipalities that are originating some of these ordinances that are allowing for these marriages to take place. And so there's an organization, if you're interested in, for the person who asked the question, called the Chosen Family Law Center. And they are based out of New York, and they operate in New York and New Jersey. And they've been really instrumental in pushing ordinances that allow for multi-partner households in progressive institutions. And so, progressive municipalities. And so I would just encourage folks to look at the Chosen Family Law Center's website for additional information.
I'd like to add too that this is one of the reasons why it is good to look at other things you can do to protect your family, right? So just kind of along the same lines, we're talking specifically about kids, but of course you can also use estate planning as a way to help protect all of the partners in the triad through documents that specify your wishes about who's going to do things for you if you're in the hospital, who's going to manage your assets for you, who do you want to have inherit your assets. One of the things that's important to consider too is that if you do have kids, there may be some options in Oregon, at least, for all three parents to legally be parents. And Jen has been successful in doing what we call third parent adoptions in certain cases here in Oregon. So going, and I know Lorena does estate planning and adoption as well, but going and talking to somebody about what those types of documents you can do to help protect your family unit is really worthwhile use of your time.
That's great. And there was actually a follow-up question asking about how people can protect their kids. And
that's going to be very county specific, like those third parent adoptions. You are not seeing those in rural areas. I don't think we're seeing those anywhere outside of the Tri-County area. Jen, have you seen them somewhere else?
No, I've done some successful in the 3 counties, Washington, Multnomah, and Clackamas. I have not attempted in a rural county. So I don't know the answer to that.
So I think that's one of the things that you start to see is that when there isn't, a unified law, there's not something that we can point to. It really comes down to what judge is showing up for your case on that particular day. It becomes harder to predict those things.
That's right. So for the listeners at home, in Oregon actually has a very permissive adoption statute. It says any person can adopt. And incidentally, this is the same place we were in with second parent adoptions back in the 70s or 80s, where the statute says any parent can adopt. But so then we would go and we'd file these second parent adoptions, and the court would go, well, but the statute doesn't tell me specifically that I can have granted adoption so that there are 2 women as parents or 2 men as parents. And so we'd see this kind of like mishmash of decisions around the state between judges who felt like, okay, that's pretty broad language, I can grant this adoption, versus judges who were like, there's not enough detail for me there, I don't know that I have authority to do this. And now we're seeing the same thing happen with third parent adoptions, just like what Lorena said, we're seeing judges here and there go, okay, any person can adopt, that's pretty broad, I can do that. And other judges saying, I'm just not so sure I have the authority to do that.
Yeah, thanks for that. And I actually just want to maybe shift gears a little bit. But this has been really helpful. But just thinking a little bit about the upcoming 4 years, and I think for the last 4 years, I think we've all felt the pain of 17 anti-trans decisions by the Trump administration. So let's talk about trans rights in the next 4 years. So, the Trump administration was consistently hostile towards the trans community. The first thing he did was removing Title IX protections for trans children in school. And then with healthcare, homeless shelters. Anyone want to talk a little bit about what you think the Biden administration can do to quickly reverse those policies and or around trans people in the military? Let's talk about it.
Yeah, so I think just sort of kind of atmospherically, generally speaking, I think we often get caught up in these reasons for concern, the Supreme Court and everything like that. I think it's really important, particularly with respect to these rights, to really step back for a moment and realize just what a better place we are with the Biden administration than really we have been coming into any administration, ever. Like the Obama administration ended with some very strong actions to protect trans rights, but it took 8 years of work on underground, like dedicated work inside administration by trans people to push the administration to feel comfortable recognizing these things. And, through the Trump years, that organizing has only gotten stronger to the point where the party and the Biden administration is embracing these rights, and we are there day one through the front door. And a lot of the actions that are being talked about as the first actions of this administration are, in fact, to protect trans rights. And how that plays out, it depends on how advanced rulemaking has gotten on particular issues. But for instance, one of the things we've been running into recently is the DeVos administration going after trans inclusive athletics policies, for instance. That has not even gone through a rulemaking process, and they're basically threatening to sue without building any durable foundation for that. That's gone, day one. I think we all might remember learning that Donald Trump had overturned the military inclusion policy via tweet, which he apparently tweeted out to impress Pompeo, just that ridiculous snap decisions. We can make those those kinds of snap decisions can be, what was that? I'm not an Avengers fan, unsnapped or something like that, wipe it all away. To the extent that other rulemaking has proceeded, there's a lot of litigation that has sort of gummed that up. And that's something that we saw at the beginning of the Trump administration, was that rules that have been passed were then they sued in front of conservative judges, the judge issues an injunction, and then Trump's administration is like, oh yeah, but we agree with the conservative judge, so this rule never goes into effect. That's what happened with the school inclusion policy. It never actually went into effect because of litigation. We can get on the other side of that now for the rules that actually have the force of law for rules. But also additionally, the Bostock decision is huge, because as Alito pointed out in a very, very angry dissent, through statutes and regulations, there are all kinds of statutes that include protection because of sex. The argument is whether that includes trans people or not. We now have a very clear textual argument and affirmation of the Supreme Court that protections because of sex include trans people. And so many of the latest actions by Donald Trump are challengeable on those grounds. That's what we see with the healthcare rule that they put out a week before the Bostock decision, that is already losing in court, with the Bostock being a tremendous anchor for the argument that no, this is not in accord with the statute where protections because of sex include trans people. But yeah, anyone else wants to jump in on this?
Well, I think that's exactly right. I think when the issue that I'm following most closely is that NB passport gender markers. And that litigation has been bogged down in Colorado for quite a while in the district court there, where it keeps getting remanded back to the agency and it keeps coming back and remanded. And I think we're going to see a different administration taking a very different position, because the position has been like, oh, this is too hard. We can't do this. Our computers won't do it. We don't know how to handle this. That I think that's all going to go away, and we're going to start to see things become unclogged in a different way. So I think that's really exciting. It's one of the first things I think is we're going to see happen, is those passport markers. And I don't know how you undo that at some point in the time by a Supreme Court. I just don't see that happening. So
that was actually the question I was going to ask, if folks thought that getting an X marker on passports was coming in our future, as Oregon was the first state to have a third gender marker. But yeah, I think that's great. I didn't know that it was, well, I guess I did. Colorado has been in the news about it for a while, but what do other folks think? You think, Matt, do you want to weigh in? And if you think that's going to happen in our future, or near future?
Yeah, I hope so. And there's all sorts of reasons actually to include an X gender marker on a passport that isn't just about those of us who identify as non-binary or trans, right? And other states, like more conservative states, have had other options for identification in the past. And so in some ways, it has become a more deeply politicized issue, and an issue more closely related to the LGBTQ rights movement. But there's plenty of history suggesting that there are lots of folks out there who don't identify as queer who would like to have this option as well. And I think this kind of goes back to some of that administrative state stuff, right? Two things to, as Lorena was talking about, which is that it is, I think it's really important to keep in mind that once this stuff happens, right? Like if an Biden administration says to the Department of State, which they can because it's an executive agency, that you should issue passports that include an X gender marker and figure out a way to do it. That once that process is in place, I think it becomes much, much harder to unwind it. And frankly, I can't think of a good reason why a federal court would interfere with that. Actually, that's not true. I can think of one good reason, but I don't want to get into it. It's too wonky. But I also just want to to sort of frame a little bit of what Nora was saying earlier. For those who are listening who aren't as deeply rooted in legal wonkery as we are, the Bostock decision, which came out recently, was about protecting transgender and gay and lesbian employees under Title VII, right, which is a federal regulation that requires prohibits employment discrimination based on sex. And so that ruling was really important. And as Nora pointed out, I think it is having it. We all saw that ruling, right, as having these sort of like really broad-reaching potential implications. And as Nora pointed out, Alito also saw that, right? We're sort of agree that this has potential broad implications. And well, I'll just pause there because Nancy, I'll wait until you ask me about sports questions before I get into those.
Okay. So great segue. So I think that one place where trans rights have always sort of come up as a question, especially in K through 12, is around facilities and around bathrooms, around locker rooms. And so let's talk about trans kids in sports. And also I just want to mention that it's not exactly the same, but it in the same genre, right? Like there is a case that Basic Rights Oregon has been really engaged in around discrimination of trans kids in schools, which is a case that Parents for Privacy had against the Dallas School District. Basic Rights Oregon came in as the defendant interveners because we were so engaged in what was happening in Dallas and standing up for Dallas to stand up for trans kids, right? And this lawsuit was basically saying that, that Dallas was wrong for standing up for trans kids and wanting to promote trans discrimination. So do you want to just mention that, Matt, as you talk a little bit about what's happening with sports?
Yeah, happy to. So the Parents for Privacy case, as Nancy, as you just mentioned, came out of the Dallas School District in response to the Dallas School District doing what we thought was the right thing and putting a safety protocol in place that allowed the student to use facilities that matched their gender identity. And the parents in that case essentially alleged that their kids were being discriminated against by being forced to use the bathroom with somebody who was transgender. And the courts, agreed with Basic Rights Oregon that is a laughable position, and it kicked the case out of court and kicked it out of court in a pretty permanent way by saying they could not refile that same complaint by amending it. And so that case went up to the Ninth Circuit, where the Ninth Circuit affirmed that decision. And now, unfortunately, parents isn't relenting and they're appealing to the Supreme Court. But I think there's really good reason to be hopeful that that case will either not be taken up at all, and if it were to be taken up, would be decided in favor of Basic Rights Oregon and the Dallas School District. Essentially, it is somewhat rare these days, at least around civil rights issues, for there to be sort of no distinction between the various courts of appeals at the federal level. And this is one of those places where essentially it's not entirely true that every court case has come down the right way, but almost every court case, the vast majority of court cases at that high level have come down saying that trans youth have the right to use facilities that match their gender identity in schools. And so it would be really unlikely, I think, for the Supreme Court to suddenly shift that position. And related, right now, there are cases around trans youth participating in sports. And the one that everybody is really watching is coming out of Connecticut right now. And that is that essentially a few female athletes, I think it's 3 female athletes, filed a complaint with the Trump's Department of Education and their Office of Civil Rights, if you want to call it that. It seems like a misnomer, to complaining that they had to compete with trans students. And OCR, the Office of Civil Rights, agreed with them and sent a letter to Connecticut, to the Connecticut Interscholastic Athletic Conference, saying that it was a violation. So complete opposite of what courts have said, saying it was a violation of Title IX to allow trans girls to compete on girls' teams. And they simultaneously, these 3 women simultaneously filed a federal court case in Connecticut alleging this stuff. Now, the background for all of that is that in Idaho, right, like a court system we don't think of as being particularly liberal, like a judge just decided a case in favor of the trans students, right? Like in 2 courts of appeals. And when I say just, I mean literally not last month anymore, but August, I think in August. And then in 2 other courts of appeals decided that those cases in the same way, applying the rationale of Bostock, right, of that case, saying that you can't discriminate in Title 7 against trans employees, applying it to Title 9 against trans students. And so the Trump administration is clearly doubling down on their efforts to eradicate the rights of trans people, but there are really good reasons to believe that the federal courts will continue to protect them.
And on those lines, in terms of legal protection, that Idaho case is one I'm definitely watching really, really closely, and that is one where Idaho passed a categorical ban on assigned male at birth athletes participating in girls' sports. There's a ban on trans girls participating, and under the statute, it was categorical, and they claimed, to back it up, that there was an absolute advantage that, I'm sitting here, 5'3", can't carry the groceries in, to read that I have like a categorical advantage against other athletes. But, that's kind of the basis. And, Matt mentioned Title IX. Also, we're looking at constitutional protection, and that is an evolving area that we're seeing more courts, especially in the aftermath of Bostock, looking at, do trans people as a class warrant extra protection under the Constitution? Without getting too in the weeds, generally the government can make rules that make distinctions between people. They don't have to work very hard to justify it. They don't have to show their work necessarily at the front end. Certain classifications, though, and certain groups warrant heightened scrutiny. Race discrimination is a big one. Gender discrimination gets this sort of middle level of scrutiny. It means the government has to justify its own actions. It has to show its real reasons, and that it was actually a good way. They were doing something important, and they actually were addressing it in a way that was well suited to the aim they're trying to do. The question is, do trans people get that heightened protection? And we are seeing, especially in the aftermath of Bostock, more and more courts are recognizing this. Some courts are saying, well, sex gets heightened protection, and Bostock says sex and trans discrimination, all the same thing, so we get it. Just easy. Some of them have gone through the full evaluation that is supposed to be gone through to determine whether a new class warrants protection, and have come to the same understanding, because it's really obvious if you look at it fairly, but it has to do with, what kind of class is this, how have they been discriminated against in the past, like a lot of different issues. And so what that means for this Idaho case is that when they're going into court, the court determined that the heightened scrutiny applied. It meant Idaho had to justify its own actions. And when Idaho came in saying that trans girls have an absolute advantage, that is just, it is not supported by the science. It's not supported by the evidence. And, you look at sports generally, there is kind of a general recognition that AMAB athletes at the elite level may experience an advantage. Most international competition has a compromise where they're basically like, well, where is the scientifically supportable line where we feel like this is a fair competition? Idaho and these other states are not doing any of that. They're just saying trans girls have an advantage, they can't play. That's not supported by the science. And what these courts are saying is, at minimum, well, you have to show that there's a problem, first of all. They can't show that there's a problem with trans girls being included. And they can't show that their categorical ban is supported by science, and so you lose. And I think that is something to watch with the Supreme Court in terms of whether the Supreme Court ultimately adopts that. But, looking at the courts from the 11th Circuit, 9th Circuit, 3rd Circuit, all these courts that have addressed this, there have been many courts that are applying this heightened scrutiny standard. I think Bostock is tremendous reinforcement of that. And so that is going to be really important moving forward for all kinds of trans rights when governments are restricting trans rights.
Thank you for that, Nora. And you're basically going to have the final word. But, I am really looking forward to decisions based on science and evidence. I think that will be great for us, great for the country, great for LGBTQ equality. The winner of the beautiful tote bag is Jack Marvin. Congratulations, Jack. Thank you all for being guests here today. And hopefully people listening feel reassured about what's happening and about your future, and that your rights are going to be protected. So let's keep on fighting for what's next. And thank you all. Take care.